Welcome to the King's Court, where we dive into the complexities of the legal system. Today, we're tackling a fascinating question about criminal trials. Why do courts or prosecutors sometimes block evidence presented by the defense? If the goal is to prove guilt beyond a reasonable doubt, and the prosecution's case is strong, wouldn't letting the defense introduce all their evidence clear up any doubts and make a conviction even stronger? And I want to thank Big Rob for providing today's question. He's been wondering about this for a while. I've tried to explain it, but I wanted to make a video to kind of really go deep into this and try to explain this. So, to understand why evidence gets excluded, we first need to know how evidence works in a criminal trial. The prosecution's job is to prove the defendant's guilt beyond a reasonable doubt. That's the highest standard in our legal system. The defense, meanwhile, aims to poke holes in that case or present alternative explanations. But here's the catch: not all evidence is allowed in court. Why? Because evidence must meet strict legal standards. For example, evidence has to be relevant, directly relates to the case. It also has to be reliable, like credible witness testimony or verified forensic data. And it can't be overly prejudicial, meaning it shouldn't unfairly sway the jury with emotional or misleading information. That's one of the reasons why, in cases like sexual assault, the victim's past sexual history is not available for impeachment evidence because it is possible that it could unfairly prejudice the jury. But why not let all evidence in? If we want to test the prosecution's case completely, why not just let everything in? Well, allowing everything could overwhelm the jury, could delay the trial, or even lead to unfair outcomes. Imagine a defense throwing wild theories with no proof. It might confuse jurors or distract from the facts. Excluding improper evidence keeps the trial focused and fair. So, when the prosecution or court moves to exclude defense evidence, it's not about hiding the truth most of the time. I will grant that prosecutions and prosecutors do try to uh, hide evidence that is against their case, but they usually have a good reason for it, or they're supposed to. Again, Rule 11 says that no attorney is supposed to make a pleading or offer to the court without having a reasonable basis for that offer. So, do attorneys go against that sometimes? Absolutely. But this is kind of assuming a perfect world here. Let's start with one of the most famous trials in history, the O.J. Simpson case in 1995. Actually, the year I was born. Simpson was accused of murdering Nicole Brown and Ron Goldman. The prosecution had a mountain of evidence: DNA, bloodstains, and a glove found at the scene. But the defense suggested the police, and more specifically, the detective Mark Furman, framed Simpson by planting evidence. Now, that's a serious claim. The defense wanted to introduce all sorts of evidence to support this conspiracy theory. They wanted to talk about Furman's past statements about race, speculative scenarios about police misconduct, but the prosecution pushed back, saying that much of what they wanted to talk about was irrelevant and unsubstantiated. Why? Because there was no concrete proof that Furman tampered with evidence or was a racist. It was mostly guesswork. So, if they had allowed this evidence in, it could have prejudiced the jury against the prosecution's case. And the court agreed and limited some of the evidence. For example, the judge restricted how far the defense could go with Furman's personal history. And because the judges don't want their cases turned into sideshows either. They don't want their cases appealed to the Court of Appeals and overturned because they've given bad evidentiary rulings. The goal wasn't to silence the defense, but to keep the jury focused on admissible evidence, like the DNA, and allowing wild theories like this, like racist cops and crazy conspiracy theories. All they do is go to muddle the truth. Their only goal is to cause basically chaos in that juror room and to confuse the jurors. In this case, it shows us that excluding evidence isn't about favoring one side versus the other. It's about sticking to what's legally sound. So let's look at another case. Let's look at Casey Anthony. We all remember where we were during the Casey Anthony trial. It took place during 2011. I was still in high school. So let's fast forward to 2011, the Casey Anthony trial. Casey, as we all remember, Casey's accused of murdering her two-year-old daughter, Kaylee. The prosecution's case centered on Casey's suspicious behavior and physical evidence, like traces of chloroform in her car. The defense, though, wanted to come at this with like a different idea. They argued that Casey's actions were shaped by trauma, explaining she'd been sexually abused by her father. They wanted to introduce evidence of this alleged abuse to explain why Casey lied or acted strangely. But here's where it got tricky. The prosecution disagreed. They objected to introducing this evidence, and they claimed it was, quote, speculative and prejudicial. And the court agreed. There was no solid evidence like witnesses, documentation, cameras, anything like that. There was no solid evidence to back up these abuse allegations. Letting this in could have prejudiced the jury against George Anthony and shifted focus from Kaylee's death to the unproven family drama in Casey's early life. So the judge excluded it. The purpose of that exclusion was to keep the trial focused on the death of Kaylee and not on this wild aberration of this assault that went on, 20, 30 years earlier. The Anthony trial is a great example of why unfair bias evidence has to be excluded. If the defense could throw out explosive but proven claims, it might sway jurors emotionally. Jurors aren't rational groups of people. They are the very common denominator is that they are 12 or 8 people that weren't smart enough to get out of jury duty. For my last case, we're going to go all the way back to 1979, the trial of serial killer Ted Bundy. Bundy was charged with multiple murders. Anyone that's watched any of those Netflix documentaries knows brutal attacks at Florida State. And the prosecution had very strong evidence. There was bite marks on victims. They matched it with his bite. There were eyewitnesses and Bundy's own incriminating behavior. But the defense decided to introduce this new evidence. They wanted to introduce psychological profiling. And they wanted to introduce it to suggest that Ted Bundy did not match the profile of the killer. Now, that's quite interesting. Scientific evidence, how can that be excluded? Well, the court has a mandate to not allow in evidence that, even scientific evidence, that hasn't been accepted. So we all know that there are scientists out there that decide to basically come up with their own crackpot theories, but the prosecution argued that it was unscientific and that by calling it scientific evidence, it could mislead the jury. And the judge agreed. Why? Because it didn't meet the legal standard for reliability under the rules of evidence. Letting it in could confuse the jurors, making them doubt solid physical evidence like the bite marks that directly tied Bundy to the crimes. This case gives us an example of a court excluding evidence to protect their trial, to protect the integrity of the trial. If untested or shaky evidence can just be admitted no matter what, it risks undermining the conviction. Any sort of like crazy evidence that could get admitted or an appeal of grounds for appeal. If judges allow this random stuff in and your client ends up getting convicted, then you have really good grounds for appeal. That's another reason why judges don't like this stuff to come in. So why not let the defense present every piece of evidence to address all doubts? The answer lies in the balance of justice. Trials aren't about throwing everything at the wall to see what sticks. They're about presenting a clear, fair case based on admissible evidence. Excluding evidence that's irrelevant, unreliable, or overly prejudicial ensures the jury focuses on the facts, not distractions. Like I said earlier, think about it. If a defense could introduce wild theories or unproven claims, it might create false doubts, not reasonable doubts, false doubts that could weaken a strong prosecution's case or even lead to wrongful acquittals. By filtering out improper evidence, Courts actually strengthen the basis for a conviction, ensuring it's built on solid ground that can withstand appeals. Guys, that's all today. I hope this taught people some stuff. Rob, I hope this is a good answer for you, man. If it's not, we'll talk about it more. If you found this helpful, guys, drop a comment, like, subscribe, and follow me on Twitter at KingsAdvisors_.